I also have my colleague Shashank Raj, who will be taking a bit of my presentation. I am slightly unwell today, but I'm going to do justice to this session. Before we begin, I would like to know, are all of you startups? And if yes, I mean, can somebody, three or four of you, tell us what has been your experience? If you want to make this interactive, I can open my presentation. I have a presentation as well. But I would like to first start with what has been your problem as far as patenting your invention is concerned. Is there a problem? Is this a general interaction that you would want to do? Or if there is any questions that you want to ask in between? I don't want to do a monologue to begin with. So just let us spend a few seconds understanding what we want out of this session. Anybody wants to volunteer?
Hi, Mr. Vedant.
Yes, hi.
I'm Anil from Smart Biz CS. We are in the Industry 4.0 domain. My basic question is that the software, when we say the software and more say similar softwares are available in the market, but still we are building some few additional feature or some additional some features what we do feel those are different from those software. So basically those can be patented or protected is my that question, since it is a software.
You're saying if you have a similar feature that is already existing in other softwares in the market, can you protect that or not?
No, not similar. Of course, similar features is there, and there is a less possibility to protect that. But what I'm saying, there are similar softwares in the market, but our software will be built some with some additional features or it will be do something differently to attract the flexibility and adaptability. So can that attract the protection?
Yes. So the plain answer to your question, Anil, is yes. It is that's a good time when I now begin. I like this question because this is what my first slide talks about, and the answer to your question is yes. It is very much possible to safeguard technical improvement or a technical solution that you have provided to a technical problem by way of your software, even though similar kind of softwares exist. So there are software, say very simple example we can take is say Amazon and Flipkart and many other similar e-commerce kind of website. But if you see, there are many patent applications that have been filed by Amazon, filed by Flipkart on specific features that has improved, say, for example, a customer experience. So if that feature is something that is giving a technical output which is better than the prior inventions, or which is solving a technical problem in a manner that it is giving an output which is surprising, which is not something, and I'm going to talk in a very layman's term right now, which is surprising means which is not something that a person skilled in the art could comprehend. If that is something, then yes, there is a potential of getting a patent on that. So this technical effect and technical output is something that Shashank will be talking about. What does technical effect and technical output mean? And we have taken up a few slides on real life patents that we want to show you, and we'll tell you what is the difference between one versus the other when it comes to technical output. Yeah.
Thank you.
So I have one question from Pranav, which says, want to understand what is patentable, what is not. Also related to software plus hardware in industrial tech, IoT plus AI systems. Okay, so that's one question more. And do we have something from Quest Logic also? Quest Technology, sorry. Okay, so I will come to the presentation bit now. Let me start and open it. Yeah, Clint. Okay, anybody can ask any question anytime. Okay, so that's fine. Clint, you want to ask something?
Hi. My actually, I do have a question. So, like, there are multiple softwares who are which are already available in market, and they will have some we already have some industry standards that is been following on, right? So, if you take an example of manufacturing industry, like the way the BOM is been configured, right? The BOM is nothing but the bill of materials. Like we will be requiring parts to manufacture something. So in that specific case, ideally, in most of the case, there is no alternative way to do that, right? So if we are also building that kind of a thing, will that if the will that be a problem? Like, can some other company come and say that you have incorporated this feature, but ideally, if a software cannot be built without that feature, can they claim that we are going against something? That's my question. So it's
So there are two aspects. One is the industry standard. Now there are certain applications, certain patents that are fundamental patents, without which you cannot build any invention further. Now those patents are something that you will have to. There are standard essential patents that we call them. You need to use that as a base to develop something. Now, yes, there will be a license required, and those licenses are available. You'll have to talk to the inventor and find out what would be the license for you to develop something like that. If there is an invention or a patent that exists with that particular company. Now, you also have to see that whether that patent exists in India or not. One of the aspects about patent is it's territorial. So, if I am filing a patent application in the US, doesn't mean that I have any protection in India. I can, or anybody can, manufacture or process. You may not be able to file a patent, definitely, because it lacks novelty then, because it's already a prior art in the US. But you can certainly manufacture your product or make your product or develop your product based on the technology, which is not filed for patent in India.
Okay, got it.
Yeah. So, but you cannot import it. You cannot import or export it to the US because, or to any other country where the patent is filed. So keep that in mind that it is territorial. If it is not in India, it's fine. You can do that.
So in general cases, I believe like MNC, they generally when they take the patent, they file it all across the region, right?
The answer is yes and no. It totally depends on their foreseeability, how they saw it. There are many companies who probably did not see India as one of the markets, so they may not file it. Second thing is, even if they have not filed it, there could be a possibility that they may file it later on. Just to get into a slight technicality here, is that a patent, when it is filed, once you file a patent, within a 12 months period of filing that application, you can file something called a PCT international application. And that PCT international application it's not that you get an international patent, it is still territorial, but your 12 months period increases to 31 months, which means that I can wait for a few more months after 12 months to see whether anybody is infringing my product in any country or there are any demands, and then file a patent there. Once this 31 months is also elapsed, technically, the person or the company is barred from filing that patent anywhere else.
Okay, got it.
Yeah. So let's move to the first slide. I wanted to clear this first. Okay, there are two more participants who raise hands. Let me see who that is. Ravindra, and anybody else? Okay.
Hello, sir. Can you hear me?
Yes.
Yeah. So my question is that if there is a certain process which is taking place in the market, which is a manually, and we are trying to make it online system, okay, digital. So can we make it that patent?
So now there is something called a method of doing business. Okay, if it's a process or a type of doing business, it's simply like it's the shops on the on your vicinity, or shop on your laptop, which is the e-commerce website. It is that. Is it something like that you're talking about?
No, sir. It is something different. It is a manually. Right now, we can say that happening. Everything is manually, but we will do the same thing. Process will be the same, but we will do it online.
Okay, you will do it online, and you will be solving a few issues that presently existed in that manual.
Yes, we
Yes,
are.
why? As I said, as my first slide it says, is software patent allowed in India? Answer is yes. In general, it is allowed. It is not something that people will say again, software patent hai, just go for copyright. You can't go for a patent in India. It's not allowed under Section 3K. That is not the case. It is allowed. There are specific ways in which it can be filed. First thing that you should keep in mind is it giving any kind of a technical advancement? What you're doing from manual to online, is it solving something? And solving something means it should not be obvious. Okay, it should not be obvious. There should be something that is that a person who understands your language and your technology is able to not comprehend. He says, okay, oh, this is something I never comprehended, in a very plain language. That's what I want to tell you. So it should not be obvious. Secondly, it should not be merely instructions, Ravindra. It should not be merely instructions, which means that it is not that I am just going to do one thing, instructing into other thing, the third thing. There should be a component or some kind of a advancement that these instructions are working on, and then giving you an output which is novel, which is something which is very different, or by solving some of the problems. So that is something that you should look at when you're looking for filing a patent in software.
Yeah, what we are trying to do that we are just minimizing the manual efforts and giving the 100%, or we can say the 99% of accuracy, which is not we are getting in the manual process.
Correct. So if you look at, say, for example, a device that you're creating, that is actually looking at the entire process, putting it online, giving it a real-time analysis, giving it the feedback to the user. I don't know what your device is. I'm just saying it, and solving all these issues. So if all these things are happening, it is not that you're merely converting into an online platform. You are solving an issue which existed in the market today. Now, if that is the case, then yes, there is a scope of filing a patent. Coming to my next point, are there certain specific ways? This is the answer to your next question. There are ways, that is the CRI guidelines that we have to follow. Those guidelines itself, I would say, are still a growing document. So it is going to take a little more time for us to get there. There's a recent judgment from the Delhi High Court, in which Justice Pratibha Singh very nicely said that in today's world, if you combine a software and a hardware, and just because of this combination you are giving a patent, and you don't give anything, if anything is not combined or embedded in a hardware, you don't give a patent. That is something that you should not do, because in today's world, everything is running on software. The hardware could be right from a car to a refrigerator. Everything is running on a software. But you must see that a patent as a whole, is it solving some problem? Is there a technical advancement over the prior art? If that is the case, which I think should be in your case, Ravindra, then yes, you can go for a patent.
And sir, one more question is that if suppose some software is available in the market, but we are can we use case of that software can we patent, which is not in the market available right now? Can we patent if something software is there, okay, and we use case of that software, can we patent?
Well, the plain answer to that would be no, because it is a new use of a known software. Yeah. So, but we'll have to look at it. So from what you're telling me, that if it's a new application, then it is not something that is patentable. But if that application is employing certain kind of a process which is novel and which is what is giving that, which is what is solving an issue that existed, then maybe we can. So it is slightly tricky. I will not be able to answer this in yes or no. I'll have to understand what that use case is.
Sure, sir. Thank you.
Can we directly file to WIPO? Yes. If you want to file directly in PCT, then you have to take something called a foreign filing permission from the Indian Patent Office, and foreign filing permission you can take and then file it with WIP if you get that permission. Usually you would get that. Sorry for a naive question. What exactly is a software patent? Can we get a software patent if it solves a problem which has well-known answer, but no software is written for it? Pranab, you'll have to speak it out. I didn't understand, but we'll take that in some time. Can you explain the technology advancement in broad? Yes, definitely. We'll talk about it. Another thing that I want to tell you is the Indian Patent Office equipped to handle software-related inventions? Much better than before. They were not earlier, but now they are. Now, coming to my next slide. Firstly, you must understand we all talk about software. The Patent Act doesn't talk about software. It does talk about software, but it does not. It talks about something called computer-related inventions. So when you say software without a hardware is possible. You can develop a software, but you probably in many cases, you may not be able to give an expression to that software or the output to that software unless it is coupled with the hardware. Okay. Now, so when in this case, when the Patent Office doesn't use merely the word software, what I think, and this is my interpretation, is that they are saying is, do not patent something that is just merely set of instructions. Okay, Shashank will be talking about a patent. Something, maybe a set of instruction that is identifying something, a set of instruction that is picking something, set of instruction that is noting down something. These are independent instructions. You know, this is not something that the Patent Office will give you as a grant. It is something called a computer-related invention. Now, a computer-related invention, they use this term, CRI. It's computer-related invention. It's basically inventions that use computers, computer network, or other programmable apparatus. Okay. Now, don't get bogged down by such language. It is something that, you know, the legal language, when people call it that way. It's basically, it should have some kind of a hardware. That's what the Patent Office says. But no, I'm going to talk further. This is a specific scenario where it was before the Delhi High Court judgment that it should be embedded or coupled with a hardware. Then it becomes a system, and then you can file a patent with it. Inventions that include that use computer network, or other programmable apparatus, and that includes inventions having one or more features achieved by means of computer program. So these two things, if you have, then there is they are called computer-related invention. I personally don't think computer-related invention is something that should be used in today's world. Software is much more better, but this is what the present law is. Okay. I'll take you to the next slide. Now, the problem comes here. What the Act says, and where the most of the problem will come, is with the presence of the word per se. Per se, it means by itself, in itself, as such, or intrinsic. Okay. This means that if you have a software which is just a software, it is not coupled with any hardware, not embedded with any hardware, or else it is not playing with any hardware to give a tangible output, then in that case, it is called per se. So section 3K, where we are talking about the entire webinar is arranged on CRI guidelines, computer-related inventions, it says that if a software is software per se, that is, the invention itself is just a software by itself, or then that is something that will not be allowed under Section 3K of the Patents Act. Okay, so that this is, I'm just building a basis, and then later on we'll tell you how, in spite of this, you should be able to get a patent. Okay, I saw some hands raised. Clint, can you ask a question, please?
Yeah, so basically my question is again related to this only. So you were saying when we are coupling this thing with hardware, it become more easier for us to file a patent, right? And a recent High Court verdict had even made a significant change. Even a software can also be patented, from what I know. So my question will be like, there is a concept of AI, right? So when we are using AI, let's say there is a feature in the market, and a certain feature is there in the software market, and we are using AI to optimize the functionality or some part of that feature, and we can be patent that if AI is like we have developed some custom algorithm to improve the functionality, can we have the patent for that particular feature?
Yes. What are you solving with that? What are you solving? Is there something that existed that that you are trying to solve? And is it because of your software you are giving some surprising output that never existed before, or there were no prior arts before that?
Okay. So in hypothetical case, let's say actually a scheduling used to happen, and it used to take like 2 hours for manual scheduling, and we have developed a custom software or AI based scheduling tool which will cut down the time drastically. By, let's say, instead of the 3 hours, we will be able to do the scheduling with 99% accuracy in, let's say, 10 minutes. So is this kind of invention patentable?
Yeah, the answer would not be straightforward, but I would say we can think of a patent on this, because it is, from what you told me, it is something that is solving a major issue that existed before. And and also, Shashank, you have to say something. Do you have something on this specific one?
Yeah, hi, Clint. Answer to your question would be, see, since you are broadly, I can say, if you're solving a problem, earlier it was happening manual, and now you have made it automatic, maybe I would say, and by that you are also cutting down the time. So the steps that you have taken to cut down that time, so that is something, if you are enabling with the help of some hardware element, that can be patented, and that can be claimed as a that can be claimed in the patent application, and that can be considered as a patentable subject matter. And if
And that hardware element can be a simple computer also. It is not that you need to have a specific hardware for that.
Okay, let's say we are talking about AI in particular. So when we are deploying AI, obviously we will be needing an infrastructure to deploy the AI, right? So
Yes.
obviously some very vague part of an infrastructure is deployed, and we can take this as an hardware. But again, the functionality of this is actually being solved by algorithm that has been written. The algorithm in the backend is going to solve this problem. So is that algorithm patentable then?
No. So what I'm trying to say here is that we are not talking about the algorithm. That's purely a software, but your algorithm is functioning with a hardware to give out that result. Your algorithm is being written or played in such a manner that it is synergistically looking at the hardware, and the hardware is allowing that hardware to do certain things which it could not do earlier.
Right.
Or which it could not do.
Got it.
Yeah. So that is bad. Yeah. As I said, mere codes or set of instruction by itself, things that are not like, it's just a set of instruction, not in connection with any other thing. So if you say, I have an algorithm, it's just an idea. Algorithm is not working with any hardware, and also not giving out any output, which is a novel output. That's something that is not allowed. So computer program per se, as I said, is not patentable. Now this is where the old thought, I would say, and use that word, ends. There was a reason why they included the word per se. Now, one of the ways is that what they want to say is, if I give just the software, then it becomes a problem, because if I'm saying, if I say the word only software and I don't use the word per se with it, I am also debarring certain kind of things that are developed on that software from giving a patent. This is a parliamentary committee amendment that they did by using the word per se. So in a way, they are saying that I am just, Patent Act is the intention is just to stop patents which are simple computer softwares which are not communicating with any other things and not doing anything, or but it is not to debar other type of computer software related inventions where a hardware is involved, a system is involved, and there is something called a means plus function claim. Shashank will be explaining that, about what that is, and such in such a manner where there are steps. These steps are coming together, playing on a hardware and giving out a novel output, or even these steps are novel in such a way that it is giving a novel output. So those kind of computer related inventions are certainly patentable. Now, I want to move to the next slide, but is there any other question? I have something in chat. Yeah, DSK, sorry, I don't have your name here. Okay.
Hello.
Yes, please go ahead.
Yeah, I have a question regarding one of the web components which we built during 2019, right? And the component is available as of free right now, right? We built a platform, basically a component, which was used to pay insurance premium online, right? And we had our resources and cost which got incurred, and we built that. But right now, it's easily open source available. So how do we put our sort of the resources which we put during those time, and at the time of raising funds, right? And how can we use those resources and capital to further keep in our books, or to show to in our books, or to use that resources to exit our existing investors, right?
You'll have to ask that again. I'm sorry, I didn't understand.
Say for example, we had developed a component, a web component, to use that component to pay the premiums online, right? And we had put our resources, say some
So
of
at that point of time, it did exist in the
no,
market.
it did not. It did not. Right now, it's available as free open source from BBPS, Bharat Bill Pay Payment Services. So at that point of time, we integrated it, and we sort of put our team and resources to develop that thing. Right now, it's available.
So, have you?
Yeah. Yeah, please go on.
So did you file any kind of IP application for that?
No,
Any
no, we did
copyright or
not. We did not. We did not.
Okay. So, see, when it comes to copyright, we'll be explaining that later. So I don't want to touch the copyright aspect right now. So one of the things that as you can see on your screen, one of the things that patent, I would say the devil is that it's called novelty. So if you've not filed a patent application for that, and if that product already exists in the market, not in your case, your own product now becomes a prior art if you want to file a patent for that now. So the novelty aspect is gone. So that is the reason why you should have either filed a patent application. We'll come to the copyright bit later on, but copyright you can still file the copyright application for that. But we'll have to understand copyright and patent, and I'm actually jumping the gun here, but the difference is that in copyright, what is protected is the code, okay, and in patent, what is protected is the functionality. So when I can make a different set of code to get the similar kind of result, and I file a copy, I'm out of your copyright. I mean, you won't be able to sue me for that. But unless in patent, there is something that we can discuss that how that happens. So right now you may not be able to do much for that, but whatever you have employed back then, it's more of a finance question. We can talk about that later because I like this question, but we can talk about that later. I have my phone number.
Sure, Vedant. I'll get in touch with you.
So going further now, the next question comes is, okay, you have a software patent, and that software patent is somehow you have been able to draft it. We draft it for you, and we want to file it. So once we file it, what happens is there's something called an examination. Most of the people who have already filed a patent here would know that there is an examination. Now, this examination, how does it happen? Now, it's pretty simple. For the first set of parameters, novelty, inventive step, and industrial applicability is something that happens for all CRI inventions also. Now, it is nothing different. Novelty, as you all know, is your patent, your invention should be new as against everything, anything in the world, which also means that it should be new against any patent publication or any non-patent publication, which means that if I have filed a patent application, and if Shashank has already noted something down and sent and put it on, or sent on a web, and it is already existing, the details of that invention is already existing. So it is not a patent. It may be existing on his website. Even that becomes a prior art. If there is a product that is existing prior to me filing a patent, that becomes a prior art. If there is a patent document that discloses my invention prior to me filing it, that becomes a prior art. So it has to be novel as against everything, and novelty is taken across as against the world. It is not कि India में novel होना चाहिए. It should be against the world. So that criteria is clear. Second is inventive step. Inventive step means, I'll put it very simply. You take a person, that person understands your technology. You do not disclose that invention to him. You do not disclose your invention to him. You do not say anything about your invention to him, and you place him there. He understands the technology. He is a person who if he looks at a particular invention that you have, he will understand or he will not understand. But the output that comes, or the function that your invention is performing, is something that is mind-blowing for him. If something that he could not comprehend, and he is the same language, he understands, he's the same technology that you are in everything. We call such person as person skilled in the art. Okay. Now that is called an inventive step. So there has to be an inventive step in your app. This thing. There should be an inventive step where a person skilled in the art is not able to comprehend your invention and says, "Yo, this is something that is very good. This is something that I could not have." Now you don't really get a person and do that. It is something. It is how you overcome from the prior arts. So most of the inventions, when you look at the examination reports, novelty pass kar lete hain bahut log. Inventive step pe there are multiple prior arts that are cited saying that, oh, it already, this is already there, this is already there. So you have to, that inventive step is something that you have to overcome. And third is industrial applicability, which is pretty straightforward. Your invention should not be frivolous. It should be industrially applicable, capable of being manufactured in a service or a manufacturing industry. That is something that is called industrial applicability. Now, I want to talk a little bit about sufficiency of disclosure. Now, the CRI guideline says that, Shashank, are you going to touch about this later on, or should I take this slide? Shashank?
I'm sorry, I was unmuted. So I think we can touch this later because there is already some information we will be discussing later on. So let it be.
Okay. So very just as a precursor, sufficiency of disclosure is basically what, why, and how. These three questions have to be answered in a manner which is very clear If it is a hardware-based invention, then you have to illustrate it with drawings, mark those drawings, and at every step or every feature, you will have to say, okay, this plus this step is happening and working with this particular component, and this is what is giving me this output. If it is a method, then just a flowchart is good, but flowchart should be in sync. One instructions gone, second instructions gone, third, not like that. It should, as a whole, perform a function. And that function you will have to very clearly mention in the flowchart. We'll be talking about that in Shashank's slide later. Working relationship between different components, how they are connected, that is very important for you to tell in a specification. Desired output should be very clearly described. Best mode enablement is very simple, that your patent should be implementable. You know, if it is not implementable, that is not something that you have to show how is the what is the best way in which your invention can be worked. Okay, substance of invention and not the form. Shashank, you'll be talking about that later. Please touch this point in greater detail, which is called, is important. I've already discussed about per se, but I want to tell you one thing, that how is it that the patent office identifies that this is you know mere software, and it is not software coupled with the hardware, as we call it as the means plus functions claim. Wherever you see these words, means for, step for, you know, those kind of things where they perform a particular function, X, Y, Z step coming together, working with the hardware to give a desired output. That is means of performing a function. That is called means plus function claims. And those claims are something that you will see most of the times will be there in the CRI type of inventions, where there are a certain set of software that is working with the hardware to give a desired output. So that is called a means plus functions claim. I want to discuss this type of claim with you. Everybody is aware of claims. Any questions on, am I going too fast? Please ask me, stop me. I'm not a monologue kind of person. So if everybody is aware of what a claim is basically the protection of your invention. It's a periphery. It's like the periphery you have around your flat, your walls, or your, if you have a bungalow, then you have a parapet wall. I would call it that. I like to correlate it with that. Whatever is inside is protected for you. Whatever is outside is not yours. So claims are basically that periphery of your invention. So what you're claiming is yours. What you're not claiming is not yours. This is a typical, this is a very typical set of claim, which I call as means plus function claim. Let's go through it very carefully. I'll take 2-3 minutes on this slide and then we'll pass it on to Shashank. Say we want, this claim says a communication device comprising. Now there is a communication device, let's say a smartphone. What it comprises of? It comprises of means for receiving audio information. Now this is a communication device that is comprising of a mean, where that means is basically to receive audio information from nearby surroundings. Second, a means to capture visual information from one or more subject at a time. A process means, a processing means integrally coupled with, you know, or receiving audio information. Communication means, and whereas wherein the said communication device further comprises another means to facilitate the storage of audio-visual information. What it is I tell you, this is a smartphone. The second mean, when you say, could be a microphone. It is something that is picking up audio information. Third is a camera, which is a visual information. This is a very typical means plus function claim for a smartphone. Third is a processor, which is a processing means. Fourth is, you know, it's basically a transmitting processed audio or visual, which could be a 4G or 5G kind of a spectrum. And the sixth could be a calling app, from where it is actually making the calls. So this is a very typical example of what a means plus function is. There are steps involved, means involved, working with the hardware, giving a specific output. So this is a means plus function claim. You should be able to read this claim in almost all CRI inventions specifically filed in India. Okay, so you need to know what that is. And any questions so far? Okay, so I'm going to give the next slide to Shashank. And Shashank, you want to present it from your end or what?
Yeah, from my end.
So I'll stop sharing, and you can please feel free to ask more questions. Yes, so Anu, Shashank is now going to talk about what a technology advance or technical advancement is. So I think that should answer your question. So far, so good, guys. Any questions? Anything that you're not understanding? Because this is not a classroom; it's more of a business this thing. So please let me know if there is anything that you want. We are here to help you out on that.
So we had discussed on this means plus function claims for a smartphone. So this is not a standard claim set for a smartphone. This we have made hypothetically just for your understanding. This is not a claim which is there for smartphone. Nobody has filed a patent for smartphone with this claim. Actual claims would have been really different. So I'll come to this technical advancement or effect. So see, when we think of software, so we cannot see if there is a hardware involved in it. We just see the programs or instruction or the algorithms or the formulas based on which the algorithm is working and giving a desired output. But as Vedant sir had told us that without the involvement of hardware element, the execution of that software would not be possible, and that is true. So that is why the means plus function, where we don't know the name of the component, but we know the functionality. So that's why we say just means and couple it with this function, and accordingly we claim it. So that's where the technical effect that comes through those claims, maybe it can be of means plus function, or it can be some other computer implemented method. So technical effect is mainly the output. In a very simple way, if I have to tell you, it's an output which we see or which we feel or which we observe through some maybe program or maybe some website. So when we suppose if there is a bottle, if you have a thermos flask, for example. So if you have to talk about the technical effect, what it is providing you. So it is basically helping you in keeping the water inside insulated. So that is the technical effect that bottle is providing. And whenever you go to buy any product in a market, so basically you see the technical effect, and based on which you buy that product. So comparing technical effect of different products decides what product you want. And from a patent angle also, it is the technical effect that talks about the advantages that it gives you, and also the enhancement that is being achieved with the help of that product or method. For obtaining a patent, technical effect is always relative. Suppose if there is a device already existing, and if you're claiming, okay, I'm able to do this, maybe I'm able to enable this device work at a certain speed, which is quite high. So you would not get patent just based on that. It will, the examiner or the patent office would first see like whether it is improved as compared to the previous ones or not. So that's where the comparison comes, where it checks for relative effect, relative technical effect, whether your patent is improved or not based on that. So technical effect would always be relative, and interpretation may vary from field to field. If suppose there is this mechanical invention, they may look at it from an angle of if there is a modularity, or if there is some kind of comfort that the product is providing, or maybe some economical significance which is there in the product. But when we talk about the software-based invention, how patent office looks at it for deciding whether the invention is technically advanced or not. So it is something that they look at how it is being enabled, and the final output that you are getting from that is whether it is solving a problem or not. So as a whole, if I have to put it in a very simple way, they would just check it as a whole, the claim set, the independent claim that you're claiming in your patent. As a whole, it is whether it is solving a problem or not. maybe there could be one step that may look like, okay, this is different, and this is something which is not there at all in the previous prior arts. But if that is just the one step, then there is a possibility that you may not get a patent. But they would check if as a whole it is giving your technical improved result or not. So based on that, they decide whether it is falling under section 3K or not. So this is the technical effect that they look at the patent office, and based on that they decide and measure whether it qualifies for section 3K or not. So any questions till here? Technical effect, because
Anup, are you
next
clear
we
on
will
this?
go for
Anup, let Anup, are you okay with this answer? Any questions you have on that? Anup Kumar Prasad?
No, sir. I'll just ask once it ends, sir.
Okay, fine.
So next, let's come to like very real situation, like how the claims are there for computer related invention. There are two examples we have, which we will demonstrate the technical effect which were achieved through this these claim set. So this one, the one which is highlighted in green color. So this patent, see, both these inventions faced objection of section 3K, but one was able to overcome the objection and other one was could not. So the reason we will discuss why this was eligible for patenting under section 3K and why it was not eligible for passing the requirement of section for passing the criteria of section 3K and for patentability. So let's see, let's read one by one what are the steps which were claimed under this method. So let's talk about what this invention is all about. You must have seen this Google. It has a feature when you speak something and it replies with some solution. Suppose if you want to ask Google, okay, what is the weather outside, or maybe you may ask it, which is the nearest restaurant in my area. So they suggest you some options, and based on that you may further ask another question saying that, okay, let me know the distance between my location and the destination location. So there is an interaction that you may do without involving anything. Maybe it is happening wirelessly, and it is happening some over maybe cloud server, or maybe they have some databases based on which they are doing this. So this invention is all about that only, providing suggested voice-based action queries. This is a patent from Google, and it is granted. And it is purely, so you know, this Google Assistant is purely a software, but still they got a patent in India. So how did they achieve this? So that it is there in this claim. First step, they are saying receiving an indication of content recently viewed on a computing device. So first thing you can see, they're linking this step with a component which is a computing device. It can be anything. It can be anything which is computing data that can be called as a computing device. I'm not sure how they have defined this term in their invention, but generally we can say this computing device is anything which is computing some data. Second step, where they are saying determining based on the indication of the content an entity reference in the content. So the just next step, step by step, they are saying that how they are achieving this, the title, how they are suggesting voice-based action queries. So one thing you can observe, you can later on also study this one step by step. What they are doing, they are linking each and every step with the next step. So suppose if you read step 3, determining a computer-based action mapped to the entity in one or more electronic databases. So whatever has happened in the above lines, you can see they are further doing something with that information using some hardware element. Here you can see there is one or more electronic databases. And based on that, what they are doing, they are generating a suggested voice-based action query that includes at least one action term that initiates performance. So this is a language that is, it may be looking a little complicated for all of you. This is called as techno-legal language. So it does not say things directly, but at the same time, it tries to cover the technology which is behind that, and very broadly also. So 2-3 observations I can make from this claim. One is this, every step that they are performing with the help of that software, they are linking a hardware element with it. Secondly, the first step is in link with the second step is in link with the above steps. This fifth step may be in conjugation with the all above steps. So that's how they link each and every information that they are providing. And finally, they come up to a I would say this is a paragraph, but a conclusion which illustrates that this is the technical effect which one can achieve if these all steps will be followed one by one. And it is all linked. If you will read it, the last step says providing a list of voice-based action queries, including the suggested 5 voice-based action query in response to receiving voice-based query input indication. So these are all achieved in the above steps only, and with the help of that, it is giving this output as a technical advancement. So this is the output that they are claiming, which is not at all disclosed anywhere. All the apps or all the software which were developed before, no such apps were able to do this, and that is why it is novel and inventive also, and it is not falling under section 3K because they have this hardware element in it. They have this, when you will read this claim as a whole, you will understand it is not just one step or two steps which is enabling this entire product to perform the function. In fact, it is the sequential steps which are being carried out. They are performing something at a time, but synergistically, and altogether giving a desired output, and which is this. And that desired output is this technical effect, which is there in this last paragraph, providing a list based. And on the contrary, if you read this claim, which is highlighted in red, so if you'll read this, okay, the title can be a computer implemented method for generating itineraries. So basically, it's a software that generates itinerary depending on the requirement of the user. If suppose I want to go to Shimla, so it may suggest me some location or the route which I should use, which will have minimum traffics, which will optimize my cost, which will make my travel maybe hassle-free. So this is this computer implemented method which is giving me all these outputs. And how it is doing that? So you can read these claims these steps one by one. In the first step, what it is doing, it is identifying a departure location. Okay, that is fine, which is happening with the help of the processor. In the second step also, what it is doing, it is identifying a time. Third step, it is identifying weather. Fourth step, it is identifying second location if the user wants to go. So you can see what it is doing. It is just instructing the processor to identify different parameters. And it is not at all linking first step with the second one. And it's not just first and second. It is not at all linking any of the steps with the above steps. So what I can see from here, it is mere instructions which is given to the processor at every step for identifying different kind of parameters. And based on that, they are maybe indicating or generating something. But as a whole, if you will see this, the first step is independent, second step is independent, third step is independent. It is not at all related at all. And at the last, what they are saying, it is comparing all the above parameters with respect to each other and giving you the desired output. So as a whole, it is not at all in link with each other. These all steps are being performed independently. And even if you see the constructional feature, which is the hardware element, so it has a processor, it has a computing device, I think. So that is not at all sufficient for showing the interaction among different components for achieving the objectives. So this is the distinction between, like, it is very much clear that interaction among different components, which is happening in this invention, the green one, and the independencies in this claim, which is not at all linked with each other. So this is something which is attracting the provision of section 3K for this particular claim, which was rejected by the patent office. Am I clear, or should we still? Is anybody? Hello.
Any questions we have for now, or can we move ahead?
Just a query, like as you mentioned about on the last slide, right? Like the technology. Could you just move to the last slide once again?
This one?
Yeah. Like solving a technical problem by providing a technical solution. So
Right.
is it necessary that it should be only a technical problem? Like if any problem I'm solving with a technical solution, like suppose I made a device for which I have been awarded to. So it used to solve a medicinal problem. Okay, like when this patient used to have severe acts and all, so it is to trigger them to sit straight or something. Okay, so we see that this is a musculoskeletal problem, and the alert system or whatever system, it is a technical solution. So can I go for patentability of it?
Yes. See how you can see from. I'll give you an example how you can understand this. So you are saying it is not technical. It is just a simple problem, like it's a general problem. That's what you're saying, right?
Haji.
So you can see from like you can understand this. I'll give you an example of a fan. Suppose if there is a fan which you have installed at your home, which is not providing sufficient air. So that is a problem for you, right? If that fan is not able to generate sufficient air, and it is not providing cooling effect in that, or maybe the windy effect inside a room, so that is a problem for all the people sitting inside that room.
True.
But when I'm saying what is the technical problem in that fan, so it could be the problem with the coil. Maybe the coil is not working sufficiently, or it's not sufficient efficiently. Maybe there could be some problem with the aerodynamics properties of that blade. So those are the technical problems which are there in the fan, and because of which it is not able to provide you sufficient air. So both are the problems. One is the general problem, which is that you are not getting sufficient air because of that fan, and the technical problem is the reason. Where is the problem? Which is that component which is creating that problem? And if the blade is heavy, or maybe if the aerodynamic properties of that blade is not appropriate, and because of which it is not providing sufficient air. So when we talk about the problems in the component, and maybe its properties, physical property or mechanical properties, so that's where those are the problems which can be called as technical.
Got it.
Yeah.
One more thing that I should say here is recently I have one of the problems I always faced is, since all of us, we all travel a lot, we exchange a lot of business cards. The problem is to store those business cards. You know, you can buy those bulky books, you can keep doing it, and the span of last 13 years, I have some 14, 15 such large books, and it is very difficult to find a person from there. You cannot really scan all the business cards. There are card scanners. Recently, there is a very small invention. There is a very small software that is called Cove Scan. I'm not marketing it. I'm just telling you that this is what it is. And that what it does is it not only scans your card, it can scan any card written in any manner. So from somehow it is able to pick the name and differentiate it with the company name, and then pick it up and produce it in your lab, in the device that your maybe a phone. And not only that, it can categorize the column of name. Wherever the name is written, the name comes. Where the company is written, email ID is written, email ID comes, country comes. So that way, so it is in a way solving a huge issue for card scanning, and it is working on all cards. Any type of card you get in front of it. I have tried it. Even that is something that is a technical enhancement, or a that it is solving. So even that could be a technical problem solving, isn't it, Shashank?
Yeah, definitely.
This was a good example, though. Yeah, I agree with that.
Yeah, so
Yeah.
somebody is asking the name. It is called COVVE, Cove Scan. All right, go ahead, please, Shashank.
Yeah, so this was all about the claims, which one was granted and one was rejected by the patent office based on the way it was presented to the patent office. So later on, these were the flowcharts that they had provided in their patent specification. So this one was granted. The observation that patent office had noted, they plainly said that these are the mere definite set of instruction in the form of an algorithm. So in every step, what it was doing, it was just identifying different parameters. And finally, it was just comparing all those parameters and giving you some results. So it was just identification and comparison, which can be even, everybody must be knowing what is bubble sorting, right? Or maybe merging. So these are all done based on purely algorithm. So these are not patentable, and the claims were written in that manner only. So that's why it was not patentable. And also they said the claims are not reflecting how it is working with how exactly it is working with the hardware. So in every step there was some instruction which was given, but how it is interacting with different hardware elements and how it is uh, maybe transmitting this information to the next component, and how the next component is analyzing and giving you the desired output, those were not at all disclosed, and that is why it faced this objection, section 3K, and it was rejected. Finally, in order to conclude this, I think any person like who is going for software-based invention and wants to protect it by filing a patent application. So at the time of drafting only, I think maybe during prosecution or maybe at the time of drafting, if for software-based invention, if these three features are taken care of well, I think tackling of objection under section 3K would be really easy, even because these are the main guidelines which is there in the CRI guidelines. And first is this: the whatever you are claiming, it should be provided with some constructional features. So that is why we say if there is a means, so that should be disclosed along with a physical element in the drawings or maybe flowchart, and that should explain its function. That will prevent it from looking as a mere software or algorithm. Secondly, that's technical effect. So we have already discussed, it should be solving as a whole, it should be solving some problem by providing a technical solution. Third is whatever you have claimed, whatever is there in the independent list. Suppose the claim that we were talking, that Google patent, which we just discussed right now. So whatever is there in that claim, it should be well supported by the description. So it is not like it is just happening one by one. The what, why, and how should be there in the description of that patent specification, and that's how it will be supporting the claim, and that's how it makes it complete for to enable it to grant. So I think that's it from my end. If there is any question on this particular aspect, please ask me.
So Shashank, if you can stop sharing, because then I can continue.
Okay.
All right. I hope that was useful for all of you, and I would like to also now talk about because there was a mobile app protection was one of the topics. Certainly, we have spoken about the CRI guidelines and how the computer-related inventions can be protected in India. We have mobile app is again a software, and the same parameters will be applicable on that as well. But apart from that, I would also like to draw your attention. Though I'm deviating a little bit, but you should know this. I should also draw your attention to other aspects that you should consider while you look at your mobile app. Now, any mobile app, first of all, the protection is also through trademarks, of course, for the name. So these are apps that you can file. All your name should be first trademark with the with the trademark registry. There is a design protection also. This we say for the graphical user interface, you can file something called a design application. Design application will protect the look and feel of your app. So that you have to file, and if you're able to file that and get a grant on that, then you have another solid protection on that. And you certainly have a copyright protection. There is no doubt about it. You can file the copyright application for that. So you have and the fourth and a very important aspect that most of the startups don't consider is signing proper agreements with your developers. This is where I'll give you a real life example that has not happened once but twice or thrice with some of the startups we helped. In Hindi we say दोस्ती यारी में काम करवाने की सोचते हैं. So basically क्या होता है, when you have an idea and you can't do it alone, you need to have somebody to develop that with you. When you say you give it to say a software coder or a company, always sign agreements with them, make payments via bank transfer, and there should be an agreement that also assigns all rights in the applications back to your company once it is done. Okay, so this is the third way in which you should be able to protect your the fourth way that you should be able to protect your mobile app. So first is definitely patents, if it is patentable and fulfills the criteria of patentability. Second is the trademark for the names. Third is your design for the graphical user interface. And fourth is the documentation, which includes an agreement that you should sign. Yeah. And then comes something that says comparison between patents and copyright. Now, you should understand one thing. The minute software comes in your mind, as I said earlier, the minute software comes in your mind, most of the people will tell you, yaar, ye to copyright hoga, isko patent nahi kar sakte. No, that's not right. So always think from this presentation, what we have told you, always think of a technical advancement. What are you improving? What are you solving? These 3 or 4 aspects, you should always think, write it down. If your software is capable of doing that, coupled with the hardware, it could be hardware could be any hardware. It need not be a hardware dedicated to that software, like a barcode scanning machine. Like a barcode scanning machine, that machine cannot scan anything else except there is a barcode and with a software that allows it to scan. No, that is one of the best systems where you can get a patent. But even on a laptop, even on your mobile phone is not doing something that it does after your software is installed on it. That is a technical enhancement. So think of it that way also, and then see. So in copyright, basically what you save is source code and object code for your softwares. In patents, it's the entire system, apparatus, device, method, which is based on that software that is protected. Second point is important, that says a different code can bring out some technical output. Hence, said different code qualifies for copyright protection. Now, I may develop a code and Shashank may develop a code, and both of them are going to give the same kind of output. Both codes are different because that is what copyright protects. Okay, but if a concept of every invention, if I have a concept and that invention is based on that concept, I've got a patent on it, I can stop people from sort of using that method and developing that particular invention per se. That's a strength of the patent. Okay. Now, if you look at the copyright, you will see that all similar. I mean, it's their example that we have given. Like you see, Amazon, Flipkart, Myntra, Meesho, all of them are e-commerce platform, and all of them have a copyright on that because it's separate codes. But certain functionalities within that platform are patentable. So you will see a lot of Shashank, what was that patent that you were talking about? Myntra had just recently filed for?
Yeah. So Myntra had launched this feature. What you can do is if you give them a photo if you click a photo of any cloth, maybe your shirt, and you want similar kind of cloth to buy. So what it does, it suggests you multiple options for the similar looking kind of looking shirts, and based on that you can see like what are the options which are available similar to the shirt which I was looking for. So it is, so what it is doing, so that is one feature which is integrated in Myntra, which might not be there in Amazon, Flipkart or Meesho. So that is making Myntra a better app for that particular purpose. So and the components which are involved in and the components which are involved in enabling that feature to happen maybe may form the part of patent.
Yeah, so such kind of features are already there, and such kind of features are patentable, and then there is a copyright aspect to it. The third part is that the term of protection for patent is 20 years, and you cannot, after 20 years it comes in the public domain. But the term of protection of copyright is 60 years after the death of the author, and there are separate at 25 years in some cases, but most of the time it is. So you have a longer protection in copyright. But you can say for some technical enhancements, you have a stronger protection in patents. Okay. Now in copyright, one of the important aspects is you don't have to essentially file a copyright application. A copyright subsists in any work that is complete. Okay. So if your codes and an application or a software is complete, then a copyright subsists in it. You can, without filing a copyright application, you can put their copyright, your company's name, all right reserved, and the year in which it was complete. Yes, why do you have to file a copyright application? To prima facie prove that that is your property when it comes to conflict. So is it advisable to file a copyright application? Yes. Is it mandatory? No. But in patents, unless you file an application, you're not going to get a grant, and you will not get a monopoly as well. Okay, so it is mandatory to file a patent application. Okay, now I think that would be my last slide. Yes, that was my last slide. If you guys want to get in touch, please take a photo of this slide, and we can also talk about any other aspects that you want, or anything that you want to know more about the presentation, or any real life problems that you're facing. Otherwise, we can close it. I think we have jumped the time a lot, Srinidhi.
Yes. Actually, before proceeding, I would also want to thank Dr. K.S. Kardam sir, who have joined us today, who took his time and efforts to join us in this webinar. Dr. Kardam sir is former senior joint controller of patents and designs at Indian Patent Office, and he is the most experienced controller with having 37 years of the experience in legal service industry, more particularly in IPR. So it is an honor for AIC and also again, I think Accuracy Legal also to have you with us, sir.
Sir, you're mute. You're mute.
Thank you, Vedant. Thank you so much.
Thank you, sir. Thank you for joining, sir. Thank you so much.
It's a very excellent presentation. I loved it, and really good examples you have illustrated. I think one can understand the difference between the patentability and non-patentability of the inventions relating to computer-related inventions. Well done, and it's very, I think, very nice presentation.
Thank you.
I really enjoyed. I slightly joined late, but I heard everything after that.
Okay. Thank you so much, sir. Thank you.
Thank you.
So
Yes,
one
sir.
last question I have is, as the presentation was nice and it was obviously too complicated for a non-legal, non-techie guy like many of the startup co-founders, right? So when a co-founder gets into a sort of product development, or sort of outsourcing a technology, like when he wants a certain things or a component to get it developed, right? We don't, like you said, dosti yaari mein, we do things, right? So at later point of time, which I'm facing, like after like 3-4 years, right? We invested, say, amount of 10 lakhs around that technology. And right now, when we raise that capital from our investors, and we want looking to help our investors to exit. But the thing is, the problem which we are facing is now the new investors are not readily accepting the fact that the amount which we invested is that technology is no longer usable for us, because they don't want to invest in the valuation which is already outdated. So earlier investors capital was used by us, but the new investors are not willing to invest in that technology anymore. Like they said, like, you don't want to invest in something which is outdated, right? So I have got two questions. Is one, how do we manage our financials, and how do we do the valuation thing? Another one is, if we look for outsourcing the new technology from other vendors, other developers, what are the things we should consider, or is there any sort of a mechanism available where we can onboard such legal counterparts to help us get on things which we are lacking, right?
Yeah. So for the purpose of valuation of patent, this is a topic that we need to discuss, separately. Not here. It's a very, very different kind of topic that we need to talk about. You can get in touch with me. I think Srindri has posted my email ID there, so you can get in touch with me. But one of the things that, and I understand your pain. Okay, first of all, don't think that I don't understand it. I understand the pain. It is very difficult for a startup founder to do everything, and we bootstrap. We don't have money. We are putting in our own money. It is very, very difficult, and I share the pain. But one of the things that you should always do is sign documents, guys. What you don't do is, most of the times you don't do is, you do not sign documents with your friends. There are no NDAs that are signed. Ideas are loose. They just keep email pe bhej diya idhar se udhar. So first of all, get serious about this. It's a business that you are developing. Of course, you're serious. I am saying get serious about signing documents. For engineers and scientists, it is something that is a waste of time. Yaar, sign kya karna hai? It's our friend, as a college mate. No, because once the opposite person or the person who's developing it sees value in it, then the antennas come up, and that's when the problem starts. Okay, so always do that. Second is, whenever you're sitting on any idea, first of all, conduct something called a patentability search, or conduct a patent search. If you want, you can engage a patent attorney. 10-20-25,000 रुपए जाएगा, कोई बात नहीं, जाने दो, लेकिन 10 लाख रुपए का नुकसान नहीं होगा. So what happens is that you do that. Once you conduct the search, what comes to your screen from the attorney is all is the state of the art. Whether you really want to go ahead with this business or not, whether people have already filed patents on that or not. What is the scenario? That is, I'm not talking about the business side. I'm talking about the IP side, the patent side. Business, of course, you would have done the business research. You would have done all that at that point of time. As you said, the solution didn't exist, but later on it came. So where was the mistake? We did not file any IP. Otherwise, we could have very easily sent them a legal notice saying that you can't do something like that. Okay, so get in touch with us if you want just a generally understanding of how we can do. And yes, don't take IP as, it is like building your own house. आपके पास 10 रुपए होते हैं, लेकिन आप जब घर बनाते हो तो आप घर हमेशा 20 रुपए का बनाते हो, 10 रुपए लोन लेते हो. Okay, so why do you do that? Why? Because you're going to stay in that house. You are going to breathe in that house. IP is like that. It is an intangible asset. So if you're saying, for now, let it be, we don't have money, don't do that. If a company is formed, put some money from somewhere and secure your rights first, because that's where the entire game is. Otherwise, you don't have anything. You don't have a capital. You don't have money. You don't have people. All you have is your idea. That has to be safeguarded. There is no way out of it. You have to do that.
Thank you, Vedant, for the answer.
Thank you. All right. Anything else, or?
Sir, just a query, sir. Sir, when we say that technological part needs to be looked after, and also when we say that, when you have said that hire an attorney for looking even before signing any document and all, and to draft it. Sir, what are the small parameters or key points you would like to light upon so that we can have an insight that yes, our things are protected right now and we are in the safe hand?
First thing that you should do is whatever your idea is, do not put that on a public platform. First thing. That is what the first thing that you should do. Don't put this on a public platform. Don't keep, you're excited about the idea. We don't want you to go and talk to 10 people. Okay. Second thing that you have to do, but can you not talk to 10 people? You have to talk to 10 people, otherwise how will you develop that idea further? So then identify those people, sign an NDA. First document is a non-disclosure agreement that you should sign. With the non-disclosure agreement, there is something called an assignment agreement. Very few people will tell you this, guys. Assignment agreement is something where you get an assignment signed by the person who is developing that idea further for you, saying that everything that will happen, all the assignment that all the rights in that that development that he does comes back to you. And of course, make payment towards that. We call it work for hire. Always pay through bank so that you are able to prove that this was made, this work was developed at your instance. You commissioned that work for it. So be careful about that. No cash payments, no delayed payment. Make the payment. If you're satisfied with it, scope of the work उसने पूरा किया है, पैसा खत्म करो, assignment का agreement sign करके, and get that out from, first back to you. And then later on, always look for filing an IP. अगर IP आपको patent में, you don't have to do big things. You just have to make a technical disclosure and file a provisional application. एक प्रोविजनल एप्लीकेशन आप फाइल कर दो, पेटेंट एप्लीकेशन, एटलीस्ट उसके बाद आप लोगों से बात कर सकते हो. यू हैव अ प्रायोरिटी डेट, अ प्रोविजनल एप्लीकेशन विल गिव यू अ प्रायोरिटी डेट, and that priority date, and then within 12 months you should file a complete application. So and then file your trademark, file your, these are small things, design, it's a cheap thing, it's not something very expensive. Patents is expensive, it should be expensive, because people who are employed on that side are engineers and scientists. And Shashank comes from BIT Mesra, he is an engineer himself, and he sits down and writes a patent. So that makes it a strong patent, it's very well trained. So the cost increases. But for copyright, for design, and for trademark, the cost is very basic. So do all that. That's what I would suggest to begin with. Okay. Yeah. Anything else? Can we close this now, guys?
Yes.
Thank you, sir. Thank you. It was a delightful session, sir, and an informative one.
All right. Thank you. Thank you so much. And anything, you have my email ID. I'll write down my phone number if you want.
Sir, you can put it in the mailbox also. I have mentioned your ID, just your phone number.
Yeah. This is my phone number. You can call me. How to sell your patent? You just find a seller. If he's interested to buy it, then comes the matter of valuing it. Valuation of that patent. A single patent is very difficult to sell. You should always have a portfolio of patents. Then you get a better valuation. But if your single patent is so fundamental that it will change the way future tech will be developed on that, then it has a big market. So you can sell it as you sell your house property. Find a seller, get in talks with him, and if he's able to, so then you can sell it, and then you value it, and then you sell it. You sell it in a way, there are no thumb rules for valuation, but there are certain market, valuation. There are, we'll go into, otherwise we'll go into a lot of details here. We'll talk about that if you want. But valuation of patents is not cheap. It is very expensive. I must tell you that. People would say that we do valuation. You should be wary about it, because very few people in India are able to do patent valuation the way it is to be done. And if as far as the sale is concerned, you can do it in 3 ways. One is one-time sale. One is you take a signing amount and a royalty. The third is you just take the royalty. Per product sale पे मैं 5% लूँगा. Okay.
So shall we conclude, sir?
Yes, I am okay. Anup, मेरे को phone कर ले भाई अब तुम. I have to go.
Final question.
All right, go ahead, Anup.
Yes, sir.
Anup, go ahead. Yes, Anup, go ahead, please. Anup Kumar, you wanted to ask something. Okay, I think he's. All right.
Okay, so it was a really informative session, sir. On behalf of entire AICP Pinnacle team, I would like to thank Vedant sir and Shashank sir for an enlightening presentation. We appreciate having this gray area clarified, and the topic was something which cannot be covered entirely in this much less amount of time. So I also want to thank the participants who have actively participated during the webinar. So I believe that the participants are definitely benefited from the today's presentation. So with this vote of thanks, we can conclude the webinar. Yes.
All right. Thank you so much. And whenever I come to Pune, I keep visiting. So let's catch up, all of you.
Yes.
Thank you.
Sure.
Thank you so much, sir.
Bye. Thank you.